approached Henry Okum, he decided to cooperate. You think if Wontumi had cooperated, it would have been this high?
Then there would be no case.
There would have been a case that, okay, go and plead guilty and then they'll give you a lower sentence. That would have been smarter for him.
But there would have been no case.
All right, abusunya sensu ahia biem ye hia se dia na ensem de ekọ ne de eba ni na ene ye transe edi ahun komo na de na asi de na ekoso se amare okasa de ma mefa MPM we e wo key point abusunya ende ensem ebre akoso wo ho na amanfo adi nkomo lawyer Kpebu abusunya oba be che na adwene e de afa Chairman Wontumi ni case no sa anso na NDC communicator eye Solomon Owusu abusunya oba be che na adwene e de afa Chairman Wontumi ni case no ho na Chairman Wontumi ono nkasa ne lawyer Appiah-Kubi abusunya ono so ababedi nkoma abusunya ende key point na enye fedi agro na ye beko ni na one by one de obi aka ye no ya fa ne kakra na wonso what the course so ankasa ha aye Ghana Politics TV meso ene o first time one you no subscribe e de ma me say any update bia nso etomu a obenya bi eti no wa share ama afoforo nso anya bi eti enti ye ba Chairman Wontumi ni case a amanfo echiremu a kame ete say eye political prosecution ena chese ye de di Chairman Wontumi na ende lawyer Kpebu echiremu a judge na o transi edi Chairman Wontumi ni case no eno anu no because say the license emma na so de komo obi na se ni pandi ko ye galamsa wo Chairman Wontumi awoso wo ena wo se e be chew enti amanfo a omo size eye aban John Dramani Mahama oni na judges for ni na no omo just as America because Chairman Wontumi o deserve say ye che no abusia this short video we meslo sende obeka me ho na ye nyina ya kwakotie aba meslo na wa subscribe e dia mama yenko
again you should control his own.
You were the lawyer who was supposed to challenge it. I didn't know.
Where's his fault? And you have not seen the challenge even on the charge sheet, and you are talking like that.
Challenge on the charge sheet. You challenge it on the charge sheet.
I think challenge it in the courtroom. The motions that he didn't file, you
let me just give you a classical example. In relation to that is not both in the UK and here. And let me make my point. Let me say, make your point. Are you going to allow us to have a decent show?
Make your point. Make sure that you also be decorous. A lawyer was his fault, indeed.
Oh, you should have been decorous in assessing the judgment of the judge. You sat on TV, a senior counsel, and sought to impugn the integrity of a judge by alleging that she released her judgment. And you think that is an example for me, a junior counsel, to learn from you? What are you talking about? Please. And you see, first of all, I have demonstrated that the reasonable thing to do is to challenge the validity of the charge sheet. If you thought that there was something wrong with it, we saw it not long ago, 2 or 3 days ago. The Council of Hanan Aluduba, when they had concerns about the charge sheet, they did the needful by going on motion on notice to challenge same. That is what any lawyer would do.
So is it conclusive that you only do that? You made your point. I wanted to challenge it in the yes. You would have been practiced. You don't understand. No, he doesn't understand. What the only thing to do is to challenge the charge sheet. And it was not my strategy.
You're being destructive. Let's maintain some decorum, please.
So, again, another interesting claim to the effect that, when it comes to the concerns that were being raised, the circumstantial evidence adopted by the judge, it is interesting that he actually even didn't seek to challenge the essence of using some circumstantial evidence when it comes to criminal trials. Because he cannot. One, if you have a witness before you, and the witness has made assertions to the effect that per his arrangement, and mind you, even before that, you presented a prosecution witness to the judge, an expert witness, an accused witness, and indicated to the judge, senior, that look, this is the person who is vested when it comes to reclamation. And questions were asked on cross-examination about the financial implications of reclamation. And your own witness accepted on oath that indeed it is not, we are not talking about small monies when it comes to reclamation, though he fell short of mentioning an amount. And a direct question was asked to you, your witness, as to whether indeed there were any financial commitments in that regard, whether Wontumi had paid for it. Wontumi had not paid. And so all the questions that were asked, understand, were questions that made it easier for the judge to connect the dots and cross the T's, and came to the irresistible conclusion that, look, Wontumi engaged with Henry Okume and Co. with the sole motive of actually engaging in illegal mining, intending to benefit from the process of that illegal mining, but not reclamation. It is one thing for Wontumi to claim that I sent him there for reclamation. It is another for Henry Okume to also claim that I was sent in there to reclaim and to mine. But at the end of the day, it is not Senior Lawyer Appiah-Kubi or Atachia who is vested in law to compare the two scenarios and reach a conclusion. It is the judge. And the judge will reach a conclusion based on examinations in chief and cross-examination and evidence available. So if at the end of the day, the judge listens to both sides and came to the conclusion that indeed Wontumi had questions to answer and proceeded at the back of that to reach a conclusion, I don't think that we can sit on this platform and say that, look, the conclusion was not sound without challenging it in the form of an appeal. My senior also made references to piercing the corporate veil and said that, oh, it is only applicable in civil matters. That is not true. Because even if a company commits a crime against the state and the state takes steps to ensure accountability, the law permits lifting of the corporate veil to go against directors of that company. So it is not accurate to claim in law that the issue of lifting of the corporate veil is only applicable when it comes to civil matters. That is not law.
Absolutely.
That point needs to be made. And we see there's also an interesting logic, especially when it comes to this case, and it has been demonstrated. You can see the tension between Senior Appiah-Kubi and that of the MPP, because they believe that he didn't do a great job. And you could see even the arguments between him and that of my brother Richard on this platform. But the reality of the matter, we can all pretend as much as we want. Evidence was presented. They were weighed. A decision was made. If you have any problem or whatsoever in relation to the decision, the appeal processes are not shut on you. And I've heard them make reference to the fact that, oh, even they were challenged, they were seeking for an interpretation and the judge proceeded to rule.
Yeah.
Richard, that is another problematic assertion and misunderstanding of the law. It is true that prior to ex parte Senator and Co., the position of the law was to the effect that lower court judges, no, I should say from the high court, they were allowed to more or less apply the law in the way they understood it. Especially if people were alleging issues of interpretation that was in actual sense not interpretation. But even prior to ex parte Senator, I remember the case of, there was a case...
Mekankan.
Yes, from Mekankan from the 70s. It was more or less influenced later on by even the Richard Anani case. The interpretation of the complaint in the provision of the act. Complaint. It was indicated in that decision that, look, judges must be more than willing to refer to the Supreme Court. But that does not also mean that when they look at the law and it is clear on the face of the record and that they can apply, they are precluded from applying. Right. They can proceed to apply. So if the judge has applied, the judges, it is your word against the judge's word. True. The judges feels that this is not an interpretation matter. Even ex parte Senator did not say that the judge has no right to apply the law. Indeed, if you read the law, that judgment, it was clear that judges are allowed to apply. And so if you have issues, you can even raise the matter of interpretation for the first time on appeal. Am I lying, Senior? Yeah. Republic versus Dexter.
No problem.
You have the legal case gives you the authority to raise the issue of interpretation for the first time on appeal. But the point I need to make is that, look, the MPP should not use their internal confusion as far as this Wontumi matter is concerned and transpose that onto our judicial architecture to give an impression that there's something wrong with the judgment. What is wrong as far as this issue is concerned is their internal confusion. And so it must be separated. But if you read the judgment and you follow the case, the conclusion was irresistible. And those who are claiming that they have identified in excess of about 20 grounds of appeal, let them say it on this table. People are making references. People are making references to charge sheet and how defective it was.
Thank you, Hamza. Thank you, Darrell. You have spent some time. This summer boy we're talking about. Many people don't even know where it is, what is happening there. The evidence of the situation on the ground, the circumstantial evidence that the trial judge relied on. What is the reality check in Samurai Boy?
A persecution, or indeed it was a prosecution to ensure that the environment is protected.
No, Kpebu, is there any defect in this particular ruling? And what hearing from Lawyer Appiah-Kubi, what is said
and
in there?
Before Senior Martin comes in, just a quick one, with your permission. I think that this is solid grounds. This is solid grounds, because I'm getting images to that effect. That the judge in the case needs to file a petition to the General Legal Counsel for Senior Appiah-Kubi to come and substantiate the allegations to the effect that the judgment was out and Wontumi had access to it before the judgment was made public. It is important.
I would be very happy if I'm given that opportunity to prove it.
And rightly so,
we effectively
will disassociate ourselves from that particular claim.
Yeah, and I'll be very happy to come and substantiate it.
I'm afraid you don't have time.
Yeah, so, let's do this. So there's naturally bias on my part. So if you say there's a defective, any defective,
this description of Wontumi as a political prisoner. And so
so the first part, I think, is there any defect in the judgment? I'm saying because of my bias, because of my bias, you won't expect that I'll do an excellent job at it. The bias being that we need to protect the forest, etc. So my reading of the judgment on the face of it, it's okay. It's okay. It's sufficient to put Wontumi where he is. It's sufficient. It's sufficient to put Wontumi where he is. Because, you see, the thing is that the judge makes the reference. Keaton, Wontumi does not deny that he gave permission to Henry Okum, right? But that permission he gave, wrong permission, because the person who was giving the permission to Henry Okum does not have a mining support services license. You see, before you do mining support services, you have to be licensed. So he was engaged in an illegality by giving that to Henry Okum. Okum told the court that he is a small-scale miner. He's not into reclamation. Reclamation is a science, so it's not just you just cover the pits and start planting.
But the reclamation has to even be approved by the ministry.
That's what I'm saying. Yes, so it's a whole procedure and the LI. If you want to do reclamation
to the ministry.
So it will be won't be the owner. Or you mean for the license? Yes. The license should be Henry Okum. And if you are going to engage somebody, you should be checking whether he's licensed for that purpose. It's just that you're going to hire a lawyer. You've not checked whether he's licensed. Anybody you see in the court premises, and in a suit, lawyer, can you help me? No, you first check. Are you a lawyer?
So that
are you a lawyer?
To will not say that I am not qualified.
He says his story is that Wontumi gave him for them to mine.
The person who wrongly engaged the wrongful person is rather guilty of providing the service than the one who did not have the qualification.
Yes, because of plea bargaining. So when they approached Henry Okum, he decided to cooperate. You think if Wontumi had cooperated, it would have been this high?
Then there would be no case.
There would have been a case that, go and plead guilty and then they'll give you a lower sentence. That would have been smarter for him.
But there would have been no case.